Hello and welcome to this Maritime London Law Commission event in partnership with Quadrant Chambers as part of London International Shipping Week, exploring how English law can be reformed to enable electronic trade documents. Before we get started, I'd like to thank the Law Commission, Quadrant Chambers, especially Sarah Longdon, who's done an awful lot of work in putting this event on live today, both in person and virtually. And whilst we have a small, perfectly selected audience in person, which is great to see, and I look forward to seeing you at a number of other events during London International Shipping Week, we also have over 300 attendees online, which I think is testament to the interest around e-bills within the shipping industry at the moment. Now, we hear a lot, particularly in the UK, about the concept of global Britain. And I tend to feel this sort of conjures up images of heavy manufacturing and the UK exporting physical goods around the world. And while I'm in no way opposed to this, I think given my day job, I do tend to feel that there is also a great story regarding the UK's central role in the facilitation of global trade, which of course has English law and dispute resolution right at its very heart. In this light, nothing says global Britain more to me than ensuring English law is able to accommodate the brave new blockchain world. Not only do I warmly welcome this consultation, but I very much look forward to hearing from the Law Commission's proposals and from our excellent panelists on the practical implications these reforms may have on the industry. I'd now like to pass over to the chair of today's session, the excellent Dr. Miriam Golby. Miriam, over to you.
Thank you very much, Joss. Is my microphone working? Can everyone hear me? Good. Okay, so I'm Miriam Golby from Queen Mary University of London. For better or worse, I've been researching the subject for almost 2 decades now, and I'm completely delighted that it's finally bearing fruit and we're seeing actual legislation, which may or may not go through, fingers crossed, that will recognize that documents of title can be in electronic form. Joining me today are a number of excellent speakers, and I've seated them in alphabetical order to help me remember where to look. On my left is Nick Austin, who's partner in Reed Smith's Transportation Industry Group. Mark Bratman, who's claims director and legal advisor for the International Transport Intermediaries Management Limited. Stephen Chapman, marine claims manager at Ascot. And then on my right, Sarah Green, law commissioner for commercial law and the common law at the Law Commission of England and Wales, and currently my boss. Michael Howard, QC at Quadrant Chambers and leader of the Admiralty Bar since 2000. And Stuart G. Cock, who's the Foundation Council chairperson for TradeLens. We will start with a presentation by Sarah Green, who will take us through the main features of the consultation and the electronic trade documents project.
Okay, thank you, Miriam. And thank you to Maritime London and to Quadrant Chambers for hosting this and allowing me to come and talk to you about it. There might be at least a couple of people in the room who've seen this before, but I do welcome the opportunity to discuss it. The Law Commission, our work is based hugely on consultation and is always improved by speaking to the people who are going to be using the law that we reform if and when we do it. So it really is valuable for me to come and do events like this. And as Joss said, this is, I think, a very exciting, overdue, I think we all think, overdue set of reforms. So it's a really good time to be a law commissioner because it feels like what we're doing here is really important. So I'm not going to talk for ages because I think that it would be valuable to have as much discussion time as possible, and there are other people on the panel who have a lot to say as well. But obviously I want to set out very briefly what we do propose so that we all know what we're talking about. So I'm just going to say a very few things about the Law Commission, just so that everybody knows if you're not familiar with exactly how we work and what we are. I realise in this job that not everybody does see exactly how we operate. So I just want to put a few disclaimers in about that. And then I'll just run through, as you can see from that, what the project is, the draft bill as it is so far, and then the difficult issues, which will hopefully be the things that we talk about today. So this slide is quite important because this is the bit that I think not everybody realises about the Law Commission. I sometimes see us referred to as a government department. We're definitely not a government department. We are an arm's length body, which means that we get commissioned to do work for the government, but we do it in an independent way. We are not a politicised body at all. We do it in a very, as I said, consultative way. We do our research. We look at the principles and the concepts involved. And then, as I said at the beginning, we talk to the people who are going to use that law. So we provide recommendations to government, and this is the disclaimer bit. We finish off with, in this case, a draft bill and a report, which will be at the beginning of next year, which we then hand over to government, and it's up to government, obviously, to decide whether or not to take that forward. In this case, we're very optimistic that they will do. There's a huge amount of support and very little opposition, which is quite unusual for a Law Commission project. But I think everybody in this space, certainly the people I've spoken to, are very supportive of this. But that's the most I can say, that I'm very optimistic. Of course, I can make no guarantees. And I've already talked about consultation and how important it is. So everything that I've said, I'm going to say today about the substance of the bill, this is not set in stone. We finished our consultation period, that finished at the end of July. We are then analysing those responses in-house, and that draft bill will probably change to some extent before we submit it to government in early 2022. Our ears are not closed though, so if anybody here today feels very strongly about anything and thinks we've missed anything, then please do speak up and do tell us. So most of this, do tell me to shut up if that's for too long. Most of this you probably know, but again, just to make it very clear that as the Law Commission of England and Wales, again, we're sometimes referred to as the UK Law Commission, and we're not that. There is a separate, there are two separate bodies elsewhere. So our remit is the law of England and Wales, but we don't work in a vacuum, and we do work with the other bodies to deal with what is obviously often UK-wide law reforms. We make those recommendations. So why Digitalize Trade? Probably don't really need this slide for the current audience, but just because it's good to see really the potential value of this, as I'm sure everybody here and online knows. This is a massive deal to the UK in so many ways, both commercially and legally. And I think a lot of people, particularly non-lawyers that we've spoken to at the Law Commission, as in the Law Commission has spoken to these people outside of the Law Commission, very surprised actually that this is an issue, and find it hard to get their head around the fact that electronic trade documents cannot be used currently in the same way as paper documents. And of course, there are lots of advantages, as we all know, to changing that. The legal problem being, of course, the very basic one that at the moment the common law does not recognise possession in relation to intangibles, and it also regards electronic trade documents as being intangible. There might be disagreement, you might not think that they are intangible, but equally these reforms are premised on the idea that it doesn't matter, because actually the idea is that tangibility is no longer relevant and shouldn't be the touchstone anyway. But that's really the main problem. And the other thing that I wanted to emphasise, and I'm sure this is going to come out in discussion later, and I hope it does, is that what we're trying to do is be as little interventionist as we can. So we're trying to remove this small but hugely significant blocker, which is you cannot possess something currently that is in electronic form. So quite a small thing, but as we all know, has huge implications. What our draft bill is trying to do is just to get rid of that blocker. Our idea at the moment, as I said, we're analysing consultation responses, and there hasn't been a huge pushback on this, is to keep that as simple as possible. Just get rid of that blocker. Then the common law can do the brilliant things that it does in historically in developing that. Once it's been given sort of permission, if you like, and I think a few common law decisions have been seeking that from Parliament, permission to extend what they already know about possession and possessibility and what that means to electronic documents. So it's quite a very very narrow focus at root. And we're just trying to make it so that the law will recognise possessibility of intangibles. And basically just make it so that those electronic documents can work in exactly the same way as their paper counterparts. So this is how we're proposing to do it. What we don't want to do, this is also worth making very clear, what we don't want to say is, of course, all intangibles can be subject to possession, because that would be a much broader change to make. We have another ongoing project at the moment, the Law Commission on Digital Assets more broadly. And so we'll probably revisit some of those questions within that project. But for this one, as I said, it's very narrowly focused. So what we're trying to do is ensure that these changes are fit for purpose without being too broad. So first we ask, is it a trade document? Is it an electronic trade document? And obviously set out what those criteria are. And as you can see there, I think the most important things to pick out, I'm not going to read these slides out to you, obviously you can all see them, but I think the most important things there are exclusive control and divestability. What we've tried to do, as I said, is really just decouple possessibility from tangibility. So what we have done with these proposals is look at paper tangible things and say, well, what is it about them that makes them possessible? What is it about them that gives them that legal functionality that we require when we're talking about documents of title? And we've taken those things out and said, if and when an electronic trade document exhibits these features, it doesn't matter. We don't care about tangibility anymore because that's no longer really such a good way of doing this. Historically, it didn't really matter because everything we wanted to possess was tangible, so the question never arose. And I think the problem was that those two things became linked in a way that they don't necessarily have to be. And now, of course, we all know we have technology, particularly at the moment, distributed ledger technology, which enables electronic things to have those characteristics. Can I have exclusive control so that I'm the only person who can exercise rights over it? We'll come back to that. And is it fully divestable? So when I transfer it to somebody else, do I lose possession of it? So that is what we've said is pretty important about paper documents. Specifically, this is what the clauses say. This one is a list. Now, there is a question about this, and there have been mixed responses in the consultation responses so far in terms of whether we should do it like this and give an exhaustive list. So if it's one of these documents, it will be subject to the proposals, and if not, not, or whether we should be more generic about it and not specify particular categories. So I think that's an open and interesting question. Obviously, we wanted to be very clear about what an electronic trade document is. The first part of that is just about making sure that there is it is the alternative form of paper. And then C1 and 2, as you can see, that's what I've been talking about. That's about those characteristics which are important for possession. Only one person can control it for obvious reasons. With a document of title, that's very important. And when I transfer it, I no longer have those rights, which is often and historically the problem with electronic documents, but not anymore. Mixed responses and consultation to this one as well. So a person has control of a document if they can use it, transfer, or otherwise dispose. I mean, it looks slightly like the old Roman law, use, abuse, dispose. There's no secret or magic as to why that is. There might be questions, I suppose, about exactly what we mean by use, and I'd be interested in views on that. Bearing in mind as well, though, that we're trying to strike this balance between getting it right and not going into too much prescriptive detail. And these clauses equate control and possession. So we all know that once in common law you have possession of something, it has all sorts of implications for the legal functionality of that thing. And that other clause there, clause 2.2, deals with the transfer of that possession. These two clauses are really just ensuring that it's about that just parity. So if you do it in relation to a paper document and you purport to do the same thing in relation to the electronic trade document, obviously it's going to look slightly different because you're not going to be writing by hand or whatever. But if you do something that purports to have the same effect, then it will do so. I can come back to these. we discuss these things. I'll come back to the slides if it helps. This is the final one. And this is really just because, of course, there will be, for a while, even if we make these reforms, many jurisdictions who don't recognise electronic trade documents. And what we don't want to do with trade that is by definition cross-jurisdictional is to invalidate any document by virtue of it's not always having been electronic or vice versa. So this clause just says, as you can see, where it changes medium, that does not thereby and necessarily invalidate it as a whatever document it is, so long as there is a statement in there and all the other information remains the same. I think that's my last slide. Yeah. So
Excellent.
I look forward to discussing some of those issues with you. I'll pass that to you.
Thank you very much, Sarah. So next on the agenda is a short presentation by Stuart G. Giving us an example, an illustrative example of the use of e-bills in liner trades, which is based on a case study, the TradeLens system.
Yeah, thanks, Miriam. So back in those pre-COVID days, I think one of the things that I enjoyed the most about my job was traveling around the world to meet some of IBM's clients. And around 5 years or so ago, I was in Lima in Peru, speaking at a conference, and started talking to the CEO of a large freight forwarding company based in Peru. And he was describing to me how at a single port in Lima, he employed 5 individuals and their bicycles to courier around documents to different parts of the port. And it was conversations like that and other conversations around the world that led IBM and Maersk to join together to launch TradeLens back in December 2018. So our mission as TradeLens is to transform container logistics for trade, to free them from legacy data systems, from manual document handling, and from poor visibility of their consignments. Since we launched in December 2018, we've been hard at work, and last year in September, we launched our first e-bill product for containerized trade. So TradeLens is both a technology platform, but also an ecosystem of organizations that come together to use it to share information and to collaborate. That ecosystem now spans 6 continents. We have customers from many different segments of industry, automotive, through to chemicals and distribution. We're working with around 10 global banks who are all key in trade finance. And we're connected to around kind of 200 ports and terminals around the world. We've got 15 different ocean carriers working with us. Particularly significant are CMA, MSC, Maersk, ONE and Hapag-Lloyd, because when you put them together, that accounts for around 60% of global containerized trade. We're working with other providers and also a couple of regulators, as you see there, in the form of government authorities. So focusing in on e-bill a bit, sort of transformation comes with a set of challenges. And if we focus in on e-bill particularly and on some of the legal challenges or legal related challenges, I think there are really 2. So the first one that Sarah eloquently described earlier is that the legal frameworks at the moment imply that a bill of lading needs to be a paper document. Now, we didn't let that get in our way, and others haven't let it get in their way of launching some kind of e-bill product. The way that we overcome that is to use a multi-party contract that we call a rule book. So everybody who wishes to use the TradeLens bill of lading signs up to the TradeLens rulebook. And the purpose of that rulebook is to make the electronic bill of lading equivalent to a paper bill for those parties that are party to that rulebook. So the other challenge that we have is that some customs agencies, quite a few customs agencies around the world, require a paper bill of lading at import to be presented to them in order to release the goods for import into the country. That trend has, over the last decade, there's been a trend for governments to remove that requirement. And one of the things that COVID has done over the last few years is really accelerate that, as governments have looked for additional ways to remove face-to-face contact. So I think, fundamentally, TradeLens is an example of an e-bill solution that's got significant support already within the industry. Changes to legislation could further accelerate the adoption that we're seeing. And I'm certainly looking forward to England and Wales taking a lead in that.
Thank you very much, Stuart. So the next item on the agenda for the event is a panel discussion. But since we have a few minutes to spare, I wondered whether anyone in the audience had any questions regarding the two presentations we've just heard at this point. So I'll just quickly summarize and repeat the question for online viewers, just in case it wasn't audible. The question was regarding cybersecurity and digital trade infrastructure, and the extent to which Stuart views this as being an achievable goal.
Well, we think it's very achievable, I guess. Otherwise, I wouldn't have a job. No, I mean, clearly, to support kind of something that by its sort of very nature is international, is something that's different from quite a lot of the things that digital platforms and technology have done before. It's not unique by any means. I mean, if you look in sort of areas of financial services and things, you've really got somewhat similar kind of things going on. Certainly it is very important that the platforms and the infrastructure that you use, as you were saying, are kind of secure, that they have the appropriate cybersecurity arrangements in place, and all these sort of things that come along with running a large sort of critical international system that has large amounts of money staked on it, right? If you can get hold of a bill of lading for 10 containers worth of laptops or something, that's a considerable amount of money that's that you've got hold of. So I think we're not starting from scratch either. There's a lot of on these sorts of things, there's also a lot of international work already going on. If you look, say, I work quite a lot with UN CFACT, who are one of the big bodies that do a lot of standardization in this area. And there's quite a lot of thinking coming out of those organizations, also from people like the DCSA in the container shipping industry, about the kind of standards that these platforms would need to adhere to do the kinds of things that you're talking about, to be secure and to be able to be compliant with the necessary legislation.
And we've also had a couple of questions coming in over Zoom. And I think they tie in quite well with what you've just said, Stuart. One is about the current EBL adoption rate worldwide. I don't know if you have any insight into what that might be. You did intimate it was growing.
Yes, so small and growing, certainly in containerized trade. I mean, in some other types of trade, say bulk and stuff, it's more established, but in kind of small pockets of quite large organizations. So a few organizations have come together and have agreed that this makes an awful lot of sense for what they're doing. And so they're a lot further ahead in, say, bulk shipping than the container industry is.
Yes, and the other question was about interoperability between or amongst current EBL providers. which, as I understand, is a big question hanging over the industry.
Yes, and I referenced kind of DCSA in one of my previous examples, and that's certainly a topic that we spend quite a lot of time talking to DCSA about. And there are lots of different aspects to interoperability, and you can, our position is that you can achieve quite a lot right now, even before the various electronic bill of lading solutions that exist are fully interoperable. So I think it's something that's going to come, and we are working with our competitors and with the DCSA to figure out how to make that interoperability work. But I don't think, well, our opinion is it's not something that you need on day one for this to work.
Yes, it's a nice goal, medium-term goal to be achieved. And I guess if we had common legal standards, that takes us one step closer to interoperability, because essentially all the different systems will be complying with the same legal requirements and criteria. So with that, I will move on to some questions for the panelists. And the first question is for Nick, who's on my left. The first question is about the extent of current use. So there is some current use, albeit not widespread. And essentially, the question is about what are the current limitations in the way in which counterparties agree on their use, because as we've seen, use is very much dependent on having a common rule book.
Thank you, Miriam. And first of all, let me add my thanks to the Law Commission, Maritime London, and of course to Quadrant for their kind hospitality today. Look, I think of all the technological changes that are coming down the track in the shipping and global trade industry. Ships need to be green, ships are going to sail around on their own. Electronic trade documents, and I think in particular e-bills, are perhaps the ones that feel closest to really sort of taking off. There does seem to be a great sense of momentum brought about by a number of factors, which we've heard about, including the pandemic, of course. And of course, you're absolutely right that e-bills have been around in this limited form for almost 20 years. I mean, Bolero was perhaps the first, if I'm not mistaken. S-Docs, many others have been around, but they are not a new concept. But of course, they exist in this very particular way that Stuart and Sarah have outlined through the sort of private club concept, the multi-partite agreement between a closed group of parties in a particular trade, where the parties agree among themselves that an otherwise paper document will be treated as an electronic document by equivalence. And the Law Commission has called those workarounds simply because of the existing state of the law regarding possession of tangibles and not intangibles. As to the limits, what of course comes out of that is that the agreements create contractual rights and impose contractual obligations only on those parties who've signed up to the agreement. Everyone knows that that is how they proceed, and the rule book, as you've said, Stuart, sets out the terms and conditions by which the parties must abide. What that means, of course, is that no one outside the club is able to invoke the rights and the obligations that would otherwise exist if the bill of lading was a truly negotiable document and enforceable against the world at large, or and usable by a third party. So it's never a living document, which is, I think, why its use has been restricted in years gone by, generally, to fixed trades of particular commodities, certainly in the bulk sector of particular commodities where the parties are known to everyone, the trade is known, the risks and challenges have been overcome in those particular sets of circumstances. But a truly global concept of trading through an electronic bill, of course, eludes the multi-partite contract model. What the Law Commission's proposals will do, of course, is in one bound, really, one very simple step, sweep all that away. And I think at least partly, and I'll come back in a minute to why I say at least partly, make some of these existing arrangements redundant, in that if you are otherwise relying on a multi-partite contract structure, and you suddenly you have the ability to transfer to a true third party, so outside of the private club, a document, and you can truly trade it, then it seems to me you have created the real, if you like, electronic bill of lading for use in trade globally. It has to come with certain safeguards, and of course the beauty of it is it's capable of endorsement and possession in the way that I've said, and it becomes, as we were discussing the other day, Miriam, legal tender. If I give you £10 online, I could give it to you as a £10 note, but we don't need an agreement between ourselves to agree that the £10 you receive online is equivalent to the paper, piece of paper that is the note. And that seems to me to be an analogous situation with a truly electronic bill of lading being created by the proposals that the Law Commission is putting through. So those are the limits. I say that existing platforms, that system might become partly redundant, because it does seem to me, and others will know, and in particular Stuart will know more than I about this, is that as we've seen with the legislation and the draft bill, there still needs to be a highly secure platform by which people have control, and only a single person has control, and exclusive use, exclusive control. And those things seem to me to be only capable of being provided by very sophisticated providers of solutions already. And I've no doubt that Stuart and others in that market are very firmly focused on the future, and in terms of the legal changes that we are seeing, not only here, but in Singapore and through the institutional model that is starting to gain some adoption.
Absolutely. So essentially, these will become more widely acceptable simply because you have more legal certainty about what you're getting. And they are understood by everybody as the same thing, not just those who are party to this rule book. So the second question I had was for Sarah, and it related very much to this idea of having common criteria, common standards, and what the link is with possession. So from a legal basis, how can data on an electronic distributed ledger be in the possession of an individual entity?
So obviously this is really key. There are several reasons, I think, why this movement has gained so much pace in the last probably 5 years. As I said, I think we all probably in this room sense that it's overdue, and there has been a real impetus in the last few years. That's partly but because of the pandemic, and because physical presence has just obviously been a lot harder to achieve in a lot of contexts. But one of the main drivers, I think, has been the technology, which finally enables us to achieve in practice what I was talking about earlier, and decouple tangibility from possessibility. And I think at the moment, what we're talking about is distributed ledger technology primarily. That's not to say that that's always going to be the only way to achieve this. And that's another thing that we're trying to do in our proposals is to be technology neutral, because at the moment we could just say if you do it on DLT, it's fine, and if you don't, it isn't. But of course, that's problematic, because who knows what the next technology is going to be and how long DLT is going to be the one to stick around. But what DLT has done is enabled control to be focused and contained over electronic things in one entity and in one controller. So giving well, at the moment, I suppose if we talk generically, it's about having a private key. So if you have a private key, that enables you. We've spoken to various technology platforms about their development, and obviously I can't go into detail about specifics, but generally what is being developed is the ability to use that private key to ensure that the document concerned can only be actively interacted with at any one time. So you can have multiple access to that document that lots of people can see it. And in fact, that's probably what we do want, because one of the benefits of distributed ledger technology is transparency. So we don't want to limit that, but what we do want to do, of course, to make sure it's possessible and to make sure it can function as a document of title without being subject to the double spend problem, which is at the root of all this, I think, is that the private key enables that to happen, so that only one person or only one entity can, to move away from the statutory drafting, only one entity can do that at any one time, because it is really all about that double spend problem. And that is historically why electronic things and electronic forms of currency, even before DLT was developed and before Bitcoin, to use the one that obviously everybody knows about, is that electronic transferable suffered from the double spend problem until we had distributed ledger technology. So it's not the only one, but it is the one that people are mostly now, I think, familiar with. And I think it is the platform that, at least for a while, we are going to be concerned with. But we don't want to specify that in our proposals, which is why we've set out those criteria. If and when that technology enables a document to have an existence which is independent of both persons and a legal system. So, right, the obvious distinction there is it's not like a debt. So a debt, of course, only exists so long as people have a claim to it and a legal system recognises it. So that's not a thing that you can possess in any meaningful legal way. Whereas an electronic document, it'll be there on the blockchain, to again use a generic example, whether anyone lays claim to it and whether there is a legal system that recognises it or gives it a name, it's still there. So that's the first thing that we thought was important about accessibility. Then the other two that I have mentioned, exclusive control, be obvious to any lawyer why exclusive control is important, and divestibility, which I think is a corollary of that. We talked about this for quite a while, didn't we? Whether we needed to have divestibility as a separate criteria or whether that was inherent in exclusive control. So we've gone back and forth a lot on that. We did come up with a couple of examples where maybe they might not be quite the same thing. So we've left them as separate criteria.
So technologically, it's perfectly possible to make something that's not tangible, possessable, which means that a major obstacle remains the legal recognition that that is the case. And obviously the Law Commission's project is attempting to address that from the point of view of English law, but obviously these documents are used internationally. So the next question, which is for Michael, is shipping being an international business, how can we achieve international recognition that electronic data constitutes a bill of lading? And until that international recognition is achieved, how do we deal with that position?
Well, before you start to ask how you get something adopted internationally, you first of all have to think about why you want it adopted internationally. And Sarah's already given you the basic reasons for wanting to have a system whereby electronic bills of lading are recognized. And I can just recapitulate shortly. The evidence is that first, there are savings of hundreds of millions of dollars a year to be made by trading electronically rather than on 3 pieces of paper. Because secondly, there's an environmental dividend, because those 3 pieces of paper are, as Stuart has shown, the cherry on the top of a vast pudding of underlying documentation. And thirdly, perhaps slightly counterintuitively, it's thought that there'll be more difficulty in committing fraud if the transactions are committed to electronic form. You'll all remember from your scrapping on charter parties that Barbara Meyerstein and Glim Mills and ENWI docs are almost the only reported cases where the fact that 3 bills of lading are issued in their original form has been used as the basic mechanism for fraud. And some of you may not remember that that's been in Scrutton at least since 1964. But of course, there are many other ways in which fraud can be committed in the course of trying to give effect to these documents. So the advantages which can be derived from replacing paper with electronic documents benefit everybody, consumers, producers, sellers, buyers, insurers, and so on. But they can't be achieved without the widespread implementation of a regime where the use of such documents is lawful and effective. Now, how do you achieve that? You can only do it with the right actors playing their part. Not in this order of importance, they include national governments, international maritime organizations, and commercial interests. Starting with governments, they of course have their own interests to serve, because they're eager to generate trade to and from their own countries. Singapore, Bahrain, and Abu Dhabi, South Korea, China, and Japan are examples of countries which are already in the process of encouraging and facilitating electronic bills of lading by adopting legislative measures to that end. And the UCC in America has, in effect, generated a code which has been adopted by all the states individually. It's not federal law, but is law in every individual state. The national governments can't be confined to parochial considerations because of the international nature of the institution of which they're dealing. So they can advance the cause of electronification, if I can call it a horrible word, in two ways. One is by entering into treaties or better international conventions which recognize and give effect to the best commercial practice. And the second is by acting as a facilitator, that is by producing a legal environment which is friendly towards the use of these electronic documents. I would say that this is the most important function of governments, and this is the one which the Law Commission is seeking to give a boost to. Secondly, you have international maritime organizations. Likewise, they are facilitators primarily. They have soft power. They can respond to governmental initiatives, or they can act on their own. They have the benefit of their status as apparently expert and objective figures, and their proposals tend to have authority because in the nature of things, their final proposals will reflect an international consensus which has already been achieved. And a useful byproduct of their work is that it reduces the scope for governmental posturing, whether on the international or the domestic stage. So such organizations can advance the cause of any worldwide legal reform by two principal means. They can provide the text of international conventions which are to be adopted by governments, or they can provide draft codes in the form of model laws. In the context of electronic bills of lading, the most important body is Untitled, which has already created two substantial types of potential law. The first is the Rotterdam rules, intended to replace the Hague, Visby, and Hamburg rules. These include measures to promote electronic transport documents, but they also illustrate one weakness of international organizations, because the Rotterdam rules cover an enormous amount of ground and have had very little general acceptance for a number of reasons, not connected with electronic bills of lading. The second type of document produced by Envisage is the model law on electronic transferable records, which is MLETR, and this has been adopted by a number of countries in the same way as the UCC has been adopted in America. In England, the Law Commission has followed a rather different path, and in my view, I'm glad to be able to say this for Sarah sitting next to me, a much better one. They've, whereas the MLETR and the UCC are extremely detailed and complex, the proposed draft statute is a very short and straightforward one, and is concerned, as Sarah has said, largely with removing a bar. if I can remind you of what the courts did in the Miliangos case in the mid-70s, up till then it was thought, as a result of a whole line of decisions culminating in a House of Lords decision in 1961, that judgments could only be given in sterling. In 1976, suddenly the House of Lords turned all this on its head and said, we're no longer saying that judgments can only be given in sterling, they can be given in any foreign currency which is appropriate. And when it was said, well, this is going to give rise to lots of problems, Lord Wilberforce was the principal architect of the decision, and said, well, these things can all be worked out in due course. And this is the approach which the courts, I think, could have taken in relation to possession of electronic documents, but in your response and data team, and in OBG and Allen, the Court of Appeal and the House of Lords, balked at the opportunity and said, oh, it's all too complicated and difficult, and we'll leave it to legislation. So what Sarah and her team have been doing, in effect, is the same simple process as was gone through in Miliangos, and just giving a common law solution, removing the main problem and leaving the subsidiary problems to be worked out in the course of time. Finally, the third category of those who can bring about change are commercial interests. And they're not just carriers and merchants, but insurers, P&I clubs, banks, forwarders, warehousemen, harbour authorities, and all those myriad people who are involved in every international shipping transaction. These are the people who are primarily and directly affected by the nature of the documents which are used in their transactions. If electronic bills of lading are a more efficient and secure method of conducting trade, all these groups will be pressing, both individually and together, for them to be adopted. When there's no legal framework in place which guarantees their efficacy, they cannot take the risk of using them in a general way. They can only do so by way of private clubs. We've heard about how TradeLens have worked with IBM and Maersk. Bolero have been going, I think, since before the turn of the millennium. And there are such organizations as eDocs Online and WaveBL and CargoX, which all have their own specific and complex body of rules and their own memberships. And these groups of people are all anxious, of course, to have effective electronic bills of lading, and they will be able to provide the pressure to enable that to be achieved. So that's why I say that the governments and the international organizations are the facilitators, but the force is going to come from the commercial organizations. There obviously are going to be different sections of the industry proceeding at different rates. But one can be reasonably confident, I think, that in due course, a sufficient worldwide infrastructure will be established, which will achieve this result.
Oh, that's very optimistic and exactly what I'd like, what I wanted to hear, Michael. Thank you very much for that response. Indeed, the ICC, which is obviously the most representative global commerce organization, is pressurizing governments, promoting the adoption of laws across the world in this field. And the G7 just last April basically committed to adopting rules that that are designed to facilitate digitalization. So I think, Michael, you may well be right that the solution is cumulative and incremental, and it will eventually happen. And it's interesting that you said that everybody needs to play their part and to move the entire global trade industry towards digitalization. This leads quite nicely on to the question I had for Stephen, which is what does lack of international recognition mean for cargo insurance? Does the use of e-bills open the door to cybercrime, and what does it mean for insurance cover?
Thank you. Good afternoon, everyone. My role here is to sort of express some thoughts on behalf of cargo insurers, and it is, as has been said by Miriam, useful to follow on from Michael's insight into the international aspects of this. The challenge, well, so firstly, the insurer's job here is really to look after the needs of their clients. And a big part of that, we've had some initial work with some of our clients in terms of trying to provide solutions in these areas. But it's always challenging when the legal framework hasn't been put in place. A particular challenge is, even if the rules are changed and law is changed in England and Wales and in a number of forward-thinking jurisdictions, unless you've got a common legal framework across most of the jurisdictions from which your clients are trading, then there are risks and uncertainty for those assureds. There must be risks out there of potential delays to their cargoes being seized by authorities, by third parties, and risks that are still probably yet to be established. So I think it is crucial that international framework is encouraged, and we get as the broad as possible sign up to, either the Law Commission proposals or the model law or some common ground across the various proposals that are out there. The other aspect, which is the second part of the question, is relating to fraud. I believe there's been some very good work about trying to provide greater security to the electronic records system, and to provide that in a more secure framework to limit types of fraud and other complex thefts. But past experience normally teaches us that the criminals are ahead of us and will find ways to exploit any system, including ones we haven't yet even thought of or established. And we've certainly seen it in other areas of global trade that where there's a will, there's a way, and if there is a will and a way, the criminals have known the wills and the ways first, and we played catch up. And I think that creates, we get back essentially to that building that consensus between the various stakeholders, and also building that international framework. So our job is, we can try and provide an insurance solution to the cargo owner, and they can proceed to make international trade a success.
Yes, I think that sounds like there may be lots of challenges ahead for insurance, but also some interesting opportunities, as in how cover can be rethought and expanded upon. And also perhaps some risks might be reduced.
I think they're good points, Miriam. I think actually probably what you would need to see is a reassessment of what the risks are going forward, because there will be, as you've highlighted there, suggested there will be risks that come out of this that aren't currently apparent, and other risks will diminish.
Yes, and then one needs to think about their insurability. These new risks, which we don't have any data on, and we don't cover yet.
And that's a very similar problem to when cyber losses were first thought about and the insurance products are starting to develop. Many insurers embraced those quite quickly, went into cyber risks coverage, and have paid a lot of claims out as a result. Others have been more reticent and waiting for a bigger data pool to be provided and established, and then provided more specific products. Ultimately, the industry needs to work with their client base and develop a new portfolio of insurance which provides cover in these areas. I'm suggesting it's quite challenging, but it does need to be worked as a partnership.
Yes, and I think one interesting thing that insurance can do, it can also provide a route to risk management through placing requirements on clients before actually providing cover in the form of subjectivities. So essentially saying, we will cover you, but the system you use must comply with these cybersecurity standards.
I think that's a good point. I think it's across the whole industry though. I'm not sure that can be driven by the cargo owners themselves. Not at least not to provide a perfect solution. They've got to be working with the shipping lines, they've got to be working with the freight forwarders, the warehouse keepers, and throughout, and try to drive, or other matters, and certainly be involved in salvage claims. He's trying to drive solutions across the whole piece of the market. Is pretty slow going.
Yeah.
But I think you do need that engagement across the whole industry to make it a success.
Absolutely. So, I mean, this leads very neatly into the question I had for Stuart, which is how are distributed ledgers currently protected from cybercrime?
And just before I answer that, Mary, I was just reflecting a bit on what Stephen was saying. I think I don't think I'm giving away any trade secrets to say that a substantial part of our time in the last few years has been working particularly with our shipping line partners on exactly this kind of thing. So understanding, what risks these kind of solutions mitigate, but equally what sort of new, unique risks these things pose, and how ourselves, carriers, cargo owners can mitigate against those risks. So one of those that people often talk about is cybersecurity. And I guess the really short answer is that distributed ledger or blockchain technologies are actually inherently more secure than some of the existing electronic technologies, and I'll talk briefly about why that is. So, I mean, cybersecurity is really just another form of what we've used to refer to as information security. And when you think of information security, you think of three kind of main things. So the confidentiality of your data, making sure that only the right parties can read it. The integrity of your data, so making sure that only authorized parties can actually alter that data in some way. And the availability of the data. So as some shipping lines found to their cost a few years ago, sometimes things can happen that make your systems and data unavailable, and that can cause some significant problems. So when you look at each of those aspects, actually, the point about blockchain or a distributed ledger is that it gets rid of the single points of failure that exist in all the previous technology solutions that we've used. So I think the easiest example of that would be if you looked at, say, the kind of integrity aspect of your data. If you think about a shared depository system or something, let's say, when you peel away all of the layers of protection and complexity around it, eventually what you'll find at the heart of any conventional technology system is a very large database that's controlled by one particular organization. And if I can get through all the levels of protection that are around that database and kind of get direct access to it, then I'm able to update the database and rewrite history or change ownership or whatever. If you then compare that to the blockchain or a distributed ledger, the real difference is that in a blockchain network, all of the participating organizations have a copy of the information, and no change happens until a majority of those participants agree that it should happen. So what you've immediately done with that kind of consensus mechanism is remove this sort of single point of control, this single point of failure that exists with the one trusted organization that you have in any other technology system and replace it with this consensus and the need for the majority of participating organizations to agree that some transaction occurs. So that's a really powerful additional defense against changing your data that can mean that you have vastly improved guarantees about the integrity of the data that's sitting on a technology platform that runs on blockchain or some of the other distributed ledger technologies.
So it's quite encouraging that technology itself is in building cybersecurity rather than adding it on as a sort of additional layer. This brings me to talking about the security of the data. It brings me to people who are very reliant on that data to actually do their jobs, and that's shipping agents. And the question I had for Mark was, what would standardization of e-bill systems mean for shipping agents?
Thank you. Well, by background, I'm the claims director at a company that insures shipping agents. That's why I'm here today. And we get to see all the sort of claims that ship agents have all over the world. We insure most of the big agents that you'll come across. And sometimes it's for their own errors and omissions, and sometimes it's not possible to separate their liability to the carrier's liability. In certain jurisdictions, they have a joint and several liability. So we also look at that as well. In terms of e-bills themselves, they've been around, as a lot of people have said here, for quite a while, including Bolero, which was, I think, started by the company I worked for, Thomas Miller, back in the 80s originally. We, as a principle for ship agents, we exclude the use of paperless trading unless it's been approved by the international group. So that's something that anyone that wants to use this has to consider, that a lot of people, their insurance will be excluded unless it's IG approved. And most of the ones that you've been speaking about today are, to my mind, IG approved. In terms of the type of claims that we see and have seen over the years, we can see that by having these systems, these standardized systems in place and removing a lot of the human element, there may be less chance of mistakes. However, we also know that even with the current systems in place, there are a lot of human input into the bills of lading. So we still see, even where there are electronic bills, the same type of mistakes, someone putting in that the cargo is going to Santiago when it should have been gone to San Diego. We've seen that. We see 1,000 tons instead of 10,000 tons. We see -5 of refrigerated cargoes instead of +5. All things. And I would have thought, as I'm not an expert on the e-bill systems, but I would have thought that if a human is inputting these things, then they could still get them wrong. Other things that we can see going wrong with just e-bills of lading is what happens when the systems go down. And not necessarily all around the world, but just in that particular port, there might be a system. We often see the agent in a particular port will often know the importer very well. So we often see people coming now without their paper bill because of they haven't paid, and that's why they don't have the bill. But they just say, "Oh, there's been a delay. Give us the cargo. You know us. We've been using you for 20 years." And often the ship agent will say, "Oh, okay, fine, we know who you are." And I can sort of see that type of thing still happening if it goes down. And sort of carrying on what other people were saying, the cyber fraud, we see a lot of that. Unfortunately, the more computer systems are brought in, the more the criminals are ahead and they have ways of getting around. And we as an insurer had some cyber fraud policies, but we're sort of stepping away from that now because it's becoming so complicated. We've decided it's not for us anymore. But what we tend to do is, if there is some kind of, then the question is, what is cyber fraud? When does it become a cyber fraud as opposed to an error and omission? So we sort of take the view that if the ship agent has been a victim of a fraud but could have spotted it and didn't, we might think that that's actually an error and omission. If it's been done and there's no way they could have spotted it, then we'll say, sorry, that's a cyber fraud type of claim. I've spoken to quite a few ship agents before coming here today. They tend to feel, even though we've been hearing that a lot of the big carriers have been behind trade lanes and stuff, that it's being driven by the big charterers, in their opinion, a lot of it. And as far as they're concerned, the agents will do whatever they're asked to do. So if everybody wants to move to e-bills, then they will move to e-bills. It's something they almost don't have a choice on. What they are worried about, and this is sort of back to the original question of the standardization, is what if there are lots and lots of different types of electronic bills and systems, and they have to pay, or they're asked to pay by a lot of these providers. So providers will come to the ship agent and say, if you prepare 1,000 bills of lading a year, our system will save you $30,000 in time, because you spend an hour doing the documents. You have to physically go around delivering them. You have to fill them out, and you have to print them. You need paper. You need ink. If you could do it on our system, it'll be much cheaper. But you obviously have to pay to use that system at the moment. A lot of it's done by a license. And I think their question is, who pays for that? Is it the charterer? Is it the owner? At the moment, sometimes it's a ship agent, and they feel that's something they shouldn't be paying for. But again, it's sort of like at the moment with television shows, it's okay if you have to pay for Netflix, but if you have to pay for Netflix and Amazon Prime, Disney Plus, and Apple TV, it suddenly becomes not such a cost-saving event after all. That's one of the things that they are worried about, is multiple systems and platforms that they might have to be on.
Yeah, it sounds like in practice it might be a cause of concern, because it could have an impact on the business model, the very core way in which they run their business. In terms of, you said that if the market wants to move to e-bills, shipping agents will move to e-bills. It's what they will do. But is the market comfortable with the technology, or do you see a skills gap among shipping agents that might slow down the uptake?
Well, as I say, I've spoken to quite a few ship agents before I came here. Most of them have said that they are quite happy with a lot of the systems, because they are actually using quite a few of the systems already. They're saying that quite a lot, as was discussed earlier, quite a lot of liner movements at the moment are being done electronically, so they are comfortable with it. So I think one of the concerns is multiple types of systems that might give them a cause for concern. But it's one of these things that I've gone around the world talking to lots of ship agents and doing sort of loss prevention talks, and they on the ground, especially foreign jurisdictions, they don't understand the English legal concepts of bills of lading. So as far as they're concerned, it's a piece of paper that they're told, stamp that, put that here, don't backdate them, and they don't realise why and what they're actually for. So I think there'll always be a bit of a problem with understanding it. And we always go around telling people, don't backdate bills of lading. And one of the guys said, well, we never knew why that was the case. And so I said to them, well, it's to do with letters of credit, and you could default the bank, and they have to be, and they had no clue. And they said, oh, if we knew that, we wouldn't have done it. And some people say, we don't have a problem here because we only backdate them by a maximum of 3 days. So that's not good. Yeah, absolutely. So as far as the ship agent is concerned, they're sort of on the ground using them every day. They're not that interested in the legal concepts of it all. They just see them as their piece of paper. They're the key. You give me the bill, I'll give you the cargo, and goodbye. That's it.
I think one interesting thing, obviously, that technology can do is increase visibility. So it might give shipping agents more visibility into what actually these pieces of paper are doing. My next question goes back to some practical aspects of working with these documents for masters. And I wanted to ask Michael about the master's position in this situation. Obviously, the master is an agent for the carrier who is the bailee of the goods. So the goods are in the physical possession, if you like, of the master. This raises questions as to the master's position when loading or discharging cargoes in jurisdictions that may not legally recognize e-bills. Do you think there might be an impact there on the master and more broadly the carrier whose agent the master is?
Yeah, well, this depends on trying to look at the known unknowns and even more the unknown unknowns. To answer if in any particular case, one would have to know they don't have to have a comprehensive knowledge of either the conflicts rules of every single country to which a cargo might be delivered. They have to have a good understanding of their social structures, and in relation to any individual cargo, what the harbour master had for breakfast that day. As you say, the master is himself not a bailee, or he's the agent for the bailee and the carrier, and I'm slightly concerned that we shouldn't get bogged down with the concept of bailment. Bailment is a sort of medieval poison coursing through the veins of modern shipping law. Yeah, and it leads people who are not shipping lawyers, even though they may be expert lawyers in other fields, to misunderstand the successive compromises which have been reached by international conventions between merchants and carriers. This is actually rather vividly illustrated to my mind by the Volker case, where bailment has somehow overturned what appears to be the intention of a whole range of international conventions, largely because there are no shipping lawyers, real shipping lawyers on the panel. And if our own Supreme Court doesn't understand its role, the role of bailment in the contract of carriage, it's not hardly to be expected that some iron ore producer in South America or a manufacturer in Japan or Korea is going to be able to do better. Well, perhaps they will. In principle, a question ought to be governed by the local conflict of laws rules. Assume that for electronic bills of lading were unrecognised for the time being by English law, but were lawful and effective by the law of Mauritania, which expressly governed the contract of carriage. And the contract of carriage culminated in discharge in England. Presumably that electronic bill of lading would be valid and effective, and it would probably be true also of cargoes shipped from the United Kingdom if the governing law of the contract of carriage permitted such a transaction. But first of all, other countries may not have the same rules. And that does mean that you're at risk, to some extent, of the jurisdiction in which any proceedings are brought. And if the local law positively makes it illegal to use electronic bills of lading, then even the English courts, notwithstanding any provision such as the Law Commission have drafted, was the part of the governing law of the contract, still the courts would not give effect to it. But there is a risk, well, one should perhaps make the optimistic assumption that foreign law is the same as English law unless the contrary is shown. Now, it's hard to imagine a positive prohibition of electronic bills of lading. They're not like music or the absence of face covering or dancing. But in practical terms, they won't be used unless they're likely to be effective. It's no use having an electronic bill of lading if it's not recognized by the local law or the local infrastructure doesn't support the technology. And conversely, the national law at any relevant port may be as e-bill friendly as you like. But the rule of law as understood in the discharge port will not prevent a local harbour master or a neighbourhood court acting under the auspices of a local law in the sense of one passed by the town council or decreed by the local warlord from using the absence of paper as a pretext for detaining the ship or the master. And as we all know, this happens in developed countries, where ships and masters are detained on grounds which are frankly lacking entirely in legality. And there is nothing really we can do in relation to electronic bills which will change this. There's no reason to suppose that the master of the ship are not still at the risk of being detained at the whim of some local grandee in even less sophisticated countries. So in the end, the question, I think, is a practical one. Is the infrastructure in place to support e-bill commerce? If it is, the masters and ship are likely not to be at risk. And if it is not, then all bets are off and they're exposed to arbitrary action. But the good news is, of course, that you don't have to trade with e-bills, even if they're available under law. And if you can see that you're trading to a country where you don't have the necessary protections, you can always go the alternative route.
Absolutely. I think it does connect somewhat to what Nick said earlier regarding familiarity and something being considered legal tender in inverted commas. Yeah. Because the beauty of paper bills, of course, is that they're recognized everywhere. And there is a pretty uniform understanding, not perfectly uniform, but pretty uniform understanding across the world of what they are and what they do. But this brings me to the next question I had for Nick, which is, do you envisage that the proposed reforms will give the market the confidence required to utilize e-bills?
Thank you. Well, that's probably the million-dollar question.
The million-dollar question, that's
where this
right.
all goes. I mean, look, I think it's going to give levels of confidence a huge boost. I think it has to be part of more, but it is a huge step that I think has come at the right time. I mean, I suppose the first thing to say about anything to do with change in the shipping industry is that adoption of new measures and new technology where not imposed by law, and actually, let's be honest, even those that are imposed by law, is a bit patchy, it's uneven, and it takes time. And that's simply because of its truly global nature and it extending into really every corner of the planet. And also, I think the lack of unified ways of achieving change outside of IMO and legal MARPOL and constructs like that. So that's a challenge. I think the other challenge is that although it's fair to say that English law, I think, is probably preeminent in shipping and international trade, it is not the only legal system in town. And you will need, as others have noted, other legal systems to adopt either something similar or the UNCITRAL model or some form of it for there to be the sort of widespread adoption. I think the standardization of systems, to your point, Mark, is really going to be important as well. And I think all of these things are challenges. But I think stepping back, I think the time has come where one can see that the wind of change is here. And I think COVID has probably been the biggest game changer of them all, because although these steps were being taken, COVID has accelerated lots of things in our lives, but it has certainly reminded everyone of the disruption that can be caused to the physical world and the advantages of dealing with things virtually, for want of a better term. And the impetus, I think, that gives to the digitalization of electronic trade documents and bills of lading is enormous. The developments in Singapore, I think, recently are of real interest, I think, from an English law point of view, because, of course, the legal system is very similar. And the Singapore government has been hugely ambitious and active in pushing digitalization, electronic bills of lading. And I think slowly governments across the world, here, Singapore and in other places, are starting to get behind the initiatives that have been there in a sort of dormant or slightly inactive form for many years. And if you have that sort of push at a governmental level, as we're seeing here, I think you increase your chances hugely of this technology and the use of trade documents being taken up in a really widespread way. The only other point I'd make is about how long it might take. So although I think confidence will be boosted by this legal change, I think other changes will come. The systems will progress. I think it's going to take time. And the phrase I heard on another panel this morning was that there'd be at least 2 years of change management required around getting used to, and it may be more than 2 years if you think of how many interests there are, from insurance, to agents, to masters, and to all the cultural and societal differences between everyone involved in shipping. One can quickly see a period of really quite some years of change management, which is a sort of, it's like a terrible phrase for getting used to something and working out how to deal with this quite seismic change in the way that we might be going about trading in an electronic way. So in summary, I think this change, if they go through, and we're all optimistic they will, don't let us down, will you, will be a huge boost to confidence in the market, but there will need to be more around it, and we'll see how long that takes.
Yes, that's just it. I think it's going to be quite exciting times with adapting to change. Change is good. Change is good in this situation.
Keep saying it.
Yeah.
And we have adapted to change, of course, unexpectedly in the last 18 months,
Exactly.
in so many ways that perhaps we couldn't have foreseen at the time. So it shows that, you know, at a human level, it's entirely achievable to do this.
Absolutely, and I so hope it all happens. I mean, this brings us to the final question, Sarah, which is about it all happening. Will the proposed reforms, should they go through, place English law at the forefront of the international legislative activity around e-bills?
So I'll refer you to Nick's comments. Obviously, we're not the first mover in this space, and I don't think anybody will be surprised at that. English law is not known for being that progressive, but of course that's part of the reason why it is so important in international trade terms. You know, it's very certain. Parties know what they're getting, and they don't want to know that, or they don't want to worry about their obligations and expectations, you know, changing with the wind. So obviously that's a real value of English commercial law. So, you know, we've got to get this right, because I agree with Miriam in this area, change is good, but it has to be managed properly. We are a preeminent jurisdiction. Something like 80% of these agreements that we've been talking about today are made under English and Welsh law. So there is a sense we won't be at the forefront in that. Well, we know, we've heard from other panelists today that there are other jurisdictions, in fact Michael referred to several, who have already moved, as well as Singapore. The danger is, if we don't move, of course, that we will fall behind and we will lose that preeminence, and that would be the worst outcome of all, I think. And government is keenly aware of that, which is part of the reason why I'm optimistic for these reforms going through. So I think the other sense that I have from talking to stakeholders, international stakeholders, in our consultative process, we have spoken to parties who work in this across the world, and there is a sense of anticipation. You know, there are some jurisdictions, because we're, again, as Nick said, we're not the only one in town, but there are some jurisdictions who are waiting to see what we do. And I don't think that's a huge surprise to any of us. So, you know, that's just a little bit of extra responsibility. But also when we've spoken to our counterparts in other jurisdictions and legal advisors in other jurisdictions, everybody's grappling with the same issues. And there's a remarkable, so I've sat as an observer on the UCC, as has Miriam, and Untitled, and we do sit as observers on other bodies that are considering these issues, and there's a remarkable amount of consensus. So I don't think there is going to be a huge problem. I'm sure it will take a while, I have absolutely no doubt about that, but I haven't got a real sense of any conflict really in terms of how we're going about this and how other, so we have Melita, we have the MLETR, and the reason that our reforms are slightly different to that is just simply that English law has its own peculiarities and we have to navigate those. There's no opposition in terms of the substance of what we're all trying to do. So that was a very long-winded way of saying. It will certainly stop us falling behind, and I think it is a really valuable opportunity for England and Wales to retain its preeminence.
Excellent, and I hope that happens. There will be a point when it's out of the Law Commission's hands and in the hands of Parliament. So we can only keep everything crossed at that point. So there have been some questions over Zoom, which I've got here in front of me. But first, if there's any burning question from the floor, from those present, I'd like to take it. So I see two questions. Three. I'll take those questions and then we can move on to the ones over Zoom. So Sarah, you were the first to raise your hand.
Thank you.
To repeat the question for the online viewers, it was to do with the practicalities of knowing who essentially the carrier should deliver to and who is the holder. So I've seen a number of demos of different systems, so I could give you some insight on that question, but I think probably Stuart might have a better knowledge, more detailed knowledge than I do after simply a few demos.
So I can explain sort of broadly how we do it, and the others are pretty similar. Fundamentally, if you wish to interact with the TradeLens electronic bill of lading, you require some credentials that allow you to access the TradeLens system. And then once you provide those credentials, if you are, say, the current owner of the, if you have, that was the wrong terminology, haven't I? So if you currently have possession of the bill of lading, then you would, for example, be able to transfer that to another organisation within the that has access to TradeLens. But as you know, this is the way this works currently is all predicated on this idea that it's a contract, that there's a group of people, organisations that have come together and agreed to use this system. So as part of that process, one of the sort of the contractual aspects of it is signing up to the rule book. The sort of more operational aspects are things like making sure that all of those parties have access to TradeLens, have the correct credentials, and in that way can kind of make that whole process work. I think as the kind of impacts of changes like the ones that are being discussed here sort of ripple through the world, the applicability of these electronic bills of lading is going to become wider than they currently are. And I think we may have to change the way that some of that kind of operationally works at the moment, so that we can exploit the kind of wider availability and use that the law would now provide us. So we've got a way that works at the moment. I guess it's somewhat simpler what we're trying to do at the moment, because it's limited to a set of people that are all very well identified, have agreed to participate, have signed up to this rule book. And I'm sure that we will figure out how to adapt it to a wider sort of usage in the future.
I was going to say it's maybe one example of where the law is ahead of technology, the first in living memory, surely.
Well, there is a sense of chicken and egg with a lot of the technology platforms that we've spoken to, because of course there is a sense, certainly with smaller enterprises, that they don't want to invest resources, or they can't afford to invest resources if they don't know what their effect is going to be. So there is a sense of waiting to see what the law promises and then developing systems that deal with that. But it all, I think it's fair to say, isn't it? It's all based essentially around having some sort of password private key, which enables you to make the necessary electronic changes or transfers or change of status to a document online. I think that's probably the most generic description. Is that fair?
Yes, it's about identifying yourself to the system. One example I've seen is you click a button. Essentially, if you're the holder, you're the only person who has a button that says surrender or transfer or endorse. You click on that button, and once you've done that, you just don't have the button anymore. So you can't double spend. And when you click surrender, you simultaneously give instructions to the carrier. So put this container on this truck with this, a license plate, or a driver with this particular identity card. So it's all done by means of, it's all done electronically, but it's about giving the person who needs the information the right information and doing it reliably, so they know that this is coming from the right person.
much like when I log into my internet bank and make a bank transfer. So a very similar kind of experience.
Right, so you were next. The question was about the kinds of technology that are available to accomplish this digitalization of bills of lading. And the question referred to non-fungible tokens and open blockchains, and whether we've given any thought to how that may be used in this particular context. And of course, Sarah is the best person to talk about this.
I'll talk about the Law Commission approach to that, and then others might want to comment on the market view. But this is a subject that's very close to my heart, and I think I mentioned in my initial presentation that we have another project ongoing at the moment, which is Border, which is about digital assets more generally, and how the law should treat those, or how the law might have to change in order to accommodate those. And NFTs is one of the big things, as you might imagine, within that project. So that's still ongoing. It's at a far slower pace than this one, just because there is so much more to consider, because as I said, this is quite narrow and focused. But you're absolutely right, and it fits in with what I was saying about being technology neutral. So I suppose the short answer is, within this particular phase of the project, if you like, because this is so time sensitive and we really need to sort this problem out now, we're not thinking about NFTs specifically, but NFTs are a big part of that second project that I mentioned, where we're thinking about how the law might respond to them and how they might be used in different contexts. And admittedly, they could be used in this context as well. So I guess the point is that the Law Commission is definitely thinking about it, but we won't have a resolution specifically about NFT forms of electronic trade documents at the same time as we make these changes. But it is definitely very much on our radar, and I think a fascinating question.
And the draft bill would certainly accommodate that option.
Yes, we've tried to make it as open
as open as
enough
possible
to account for any technological form that at the moment we can imagine, which is about as much as we can do, I think. But I don't know about the market. You know, if anyone has any feelings about
I mean, the slightly flippant answer is that the average tanker client of mine dealing with as per tank voy, or in which you might occasionally see the Y2K clause still there from 1999, hasn't certainly across my desk got to grips with NFTs yet. But as we've seen, change is coming rapidly, so it may not be too long.
Good question, that.
Yeah.
And you had the third question. So the question was regarding whether, if the platform provider where the e-bills are being transacted in, if that provider goes bankrupt or suffers some other kind of issue, would that automatically mean that the bills become inaccessible and people aren't able to use them anymore? And I suppose this has some parallels with, for example, your paper bill of lading being with a courier and the courier's planes being grounded, say, or the courier being becoming unable to deliver. I wonder if you had that sort of parallel in mind. It's a very interesting question. Stuart, I'm afraid I'm going to put this to you.
I thought I was going to have a quiet time on the panel of lawyers.
Really sorry about this.
I would just say, before Stuart starts, we've quite often had the question, haven't we, about, well, one of the problems with making e-bills a substitute for paper bills of lading is that you can lose them and destroy them. And you know, we've had to say several times that exactly the same can happen.
Yeah,
I know that wasn't your question, but I'm just saying that's something that we hear a lot, so it'd be interesting to see what the technologist's response to that is.
So I think the way you kind of characterize the solution, certainly for what we do, is correct. So there are many organizations that participate in the blockchain that underpins what TradeLens is doing, but the people who are kind of who have possession of the e-bills and are transacting with them access it through the TradeLens platform. So if, say, IBM was to go bankrupt, there is, for those of you of a certain age, maybe, anyway. So if IBM was to go bankrupt, suffer a particular incident or something. In the particular solution that we have, every other participant in that blockchain network, who in this case would primarily be the ocean carriers, has a copy of the ledger that records those e-bills. So even if IBM goes bankrupt, you can't access the platform, there is a permanent record out there in a set of other entities that you could then use to kind of resurrect the state that things were in at the point that incident occurred. You wouldn't be doing it instantaneously, but there would be a sort of technical mechanism to bring that back, which is something you don't have if I don't know, a fire consumes the building in which your paper bills of lading.
That's what I've been telling people, that actually, so I'm glad you've confirmed that, because I've already said it several times, that actually having these electronic forms is there's more backup than there isn't.
I'm afraid I'm going to have to say no to your second question, because it's been brought to my attention that it is 5 o'clock and we were supposed to stop at 5. I did have a couple of interesting questions from Zoom. How will customs look at e-bills of lading? Well, they will need to be given access to the platform to do so. And I think, as Stuart said earlier, if you look at TradeLens, that is one example where customs authorities are actually given access to the platform. And I also had an interesting question about control. What we will do is I will discuss it with Sarah, because I think she'll like this question, and we will get back to everyone on it at a later date. I do apologize, but I have been asked to bring the session to a close. Please do show your appreciation of our wonderful panelists. I really hope you enjoyed the discussion today. Thank you very much.